Okay, we've now at exactly on time for 12:25. I now welcome a representative from the Motor Trades Association of Australia. I welcome you. I understand information on parliamentary privilege and the protection of witnesses and evidence has been provided to you for the Hansard record. Please state your full name and the capacity in which you appear this afternoon.
Thank you, Chair. Richard Dudley, Chief Executive Officer of the Motor Trades Association of Australia.
I now invite you to make a short opening statement, after which we'll have questions. Thank you very much, Mr Dudley.
Thank you, Chair. Senators. Wow, what a contrast. In the last few hours, I think the committee has had answered in unequivocal terms what a power imbalance looks like in the automotive sector in the franchise. You heard from a dealer with almost 100 employees, a 53-year relationship that you could argue was a partnership for those 53 years, was an epitome of a sound working relationship with the hallmarks of respect, mutual benefit, for the benefit of Australian consumers, who in March this year found out that that was worth nothing. And then we've just heard from my colleagues representing the manufacturers and their distributors in this country, that qualified down to a 0.33%. If you needed no other evidence before this committee about the problems that dealers have encompassed for the last 20 years in terms of when the relationship turns sour, I think you've got it in spades. To have that issue of relationship breakdown and the problems that we have enunciated along with other associations to various inquiries for the last 20 years put down to a 0.33% quantum number is beyond belief. We thank the committee and chairs for extending the terms of reference of this inquiry to look at the broader relationship between manufacturers and distributors and dealers. It's an important area to examine. We also thank this committee and other committees who have been examining the franchising sector and in particular the unique nature of new car retailing, and welcome the changes that have been secured to date and indeed planned, but we should not stop with those that have been achieved so far. We have a long way to go. MTAA has reviewed the submissions of manufacturers, distributors and their representative body, the Federal Chamber of Automotive Industries, and we've listened carefully to the testimony just presented. MTAA remains perplexed but unsurprised by their common opposition to any further regulation and their contention that additional changes may negatively impact future investment by manufacturers, distributors in the Australian market. MTAA would respectfully suggest such a campaign, as demonstrated through the submissions to this committee, is less about future market investments and more about the avoidance of overdue and necessary constraints on exploitative conduct by some manufacturers and distributors. After all, brands have come and gone in the Australian market and indeed in some cases have returned again. The manufacturer-distributor submissions generally assert that dealers are well-resourced and some are public companies which can effectively look after themselves. I think, as we've heard this morning, that may not necessarily be the case. Such statements imply that there is no power imbalance and misses the fundamental point that in business format franchising, the size of a dealership is irrelevant, as dealers, like all franchisees, lose control over expenditure decisions once they enter into the system. This gives rise to the potential for exploitative conduct. The so-called support by manufacturers and distributors of adequacy in terms of the current franchising code belies the fact that FCAI, the representative body of manufacturers and distributor members, has at all times prior to the introduction of the franchising code and following its introduction, and even today, consistently maintain that manufacturers and distributors are not franchisors. With respect. If they're not franchisors and car dealers are not franchisees, what are they? Many distributors state in their submissions to the committee that the current regulations are adequate and therefore no changes should be made. In addition, at least one distributor asserts that Australia's franchising laws and regulations are considered to be some of the world's most comprehensive and protective regimes for franchisees. The same distributor has stated publicly that it has not introduced an agency model in certain countries due to overseas franchise regulations. And again, we heard from the United States NADA this morning on that point. However, it's clear that the lack of regulatory control in Australia permits it to make a unilateral change to its business model contrary to the wishes of its own dealers and to introduce an agency model. It says it will do so within the parameters of the franchising code, as if to say that that is appropriate. It has to comply with the code because of the specific definitions contained in the code as a motor vehicle dealer agreement being a franchisee. However, the new agency model proposed by the manufacturer-distributor does not have the usual features and characteristics of a franchise, and therefore it's questionable whether the code should apply to a non-franchise agreement. Recent developments in the retail automotive industry relating to the withdrawal of Holden from the Australian market and the unilateral decision by a few manufacturer distributors mentioned this morning to unilaterally change the franchise business model to an agency model without any regulatory restraint under the code further demonstrates the weakness of the current code to provide fair and effective remedies for dealers. While MTAA is not opposed and has said this consistently for over 20 years to distributors, manufacturers making changes to reflect market developments, they need to take place in a fair and equitable manner. While one distributor refers to the benefits of an agency model in reducing the risk for dealers by no longer being required to finance the purchase of cars for resale, the manufacturer does not consider or state the overall impact of profitability on dealers and the loss of margins they will incur. In any event, many distributors have changed the basic business model in recent years by unilaterally reducing dealer margins. I won't go on with the rest of our opening points because I think they've been more adequately expressed by previous witnesses to this committee, and thank them for their courage in being able to appear and to be able to point out. We have consistently provided suggestions and solutions. We are grateful for the changes that have been made to date, but while the focus is on this particular industry, the importance of this industry to the Australia's reliance on road transport, we should not stop, and we look forward to assisting the committee in any recommendations it can make to put in further reforms in this critically important area.
Thank you very much. I'm just going to commence with a couple of brief questions before I hand over to Senator O'Neill. Can I ask, please, in terms of your structure as a membership organisation, the difference between motor traders and dealers? Because I would note, for example, that you'll have auto repairers and the like also as your members. But nevertheless, you come to a very similar position to the Dealers Association. Can you connect for us the broader issues here, not just in terms of the impact on dealerships, but the impact across the motor trades industry of some of the directions that are taking place that are being led by vehicle importers?
Thank you, Chair. The Motor Trades Association of Australia is the national federal body of various state and territory motor trades associations and automobile chambers of commerce. They in turn have tens of thousands of business representatives in the automotive industries, ranging from new car sales all the way through to recycling. So in fact, our constituency is everyone from those post-manufacturing through to the natural end of life of a vehicle, if you like, and everything in between. So we have as member constituents new car dealers, used car dealers, independent mechanical repairers, tyre retailers, fuel retailers, dismantlers and recyclers, specialist professions such as brakes, steering, etc. So MTAA is a national federated body, doesn't have those members as direct members, but my state and territory association members have those constituents as members. It affords us the ability to be able to look at broad policy, broad regulation, particularly at the Commonwealth level, the interaction with Commonwealth laws and regulations with state regulations and laws, and it allows us the ability to look for similarities that are occurring across each of the industries within the automotive sector, and also from time to time it promotes very, very rigorous debate within our organisations because in many circumstances they are naturally competing industries in their own right. We share almost identical views with the Australian Automotive Dealers Association on this. We share, in many cases, the same membership base in terms of dealers. That's not MTAA and ADA. ADA are a direct federal body with those dealers as direct members. Invariably, many of the dealers are members of my member associations.
So to put that in context, what does things like direct sales and agency agreements mean in terms of the entire small business food chain of your members? Is it more likely direct sales model about servicing, repair, sales, parts get locked down to the importing company and a smaller group of businesses?
Sorry, Chair, I lost a little bit of that, but if I heard you correctly, it's important on two fronts. The activities in new car dealer relationships with manufacturer/distributors can actually give you an early indication of changes in business models that might be occurring across the broader small business area. Alternatively, we can see things from time to time in smaller subsets of that same industry, such as parts, etc., which may tend to filter upwards and give us an early lead on policy or regulatory problems that might occur as industries naturally consolidate due to changing market conditions or promote other small business issues. For example, we have been advocating very heavily on unfair contract terms and conditions, which is a broader small business market, but which has absolutely equal importance in terms of new car retailing. We've been also very heavily involved over a long period of time on collective bargaining and the ability to have that more readily available, and similarly dispute resolution mechanisms and the ability to have those to provide timely and cost-effective means for businesses, whether they be small, micro, medium, for an effective resolution of those. So the thing that we bring to the table, I think, is the ability to have early notification across many different automotive industries and use those to our best advantage in terms of our relationships in putting forward policy and regulation suggestions.
So can I ask in that context, firstly, what trends you are seeing and whether you've got any particular concerns? I would expect, for example, that your members will be working hard to keep up with trends in electric vehicles, and yet some of the companies involved in that I know there are issues with how intellectual property around manuals, etc., gets locked down. In terms of an end-to-end model where smaller businesses are locked out, or diversity of business is locked out, what trends do you see, and are there any particular trends around electric vehicles?
There are certainly trends around electric vehicles, in particular training. Most of my member associations are the largest automotive training providers in the country. So they are either invariably training automotive apprentices across the various professions, or indeed an employer host of apprentices, as well as training and providing those apprentices to various industries in the auto sector. So we have a very, very sound knowledge in terms of changes that are occurring to the manufacture of motor vehicles, to the training that's necessary for those motor vehicles. Electrification and hydrogen are very much at the top. You do not want technicians necessarily trying to apply normal mechanical training to an electric vehicle without thoroughly understanding the implications of what an electric vehicle is all about, the circuitry that's involved in those. So there's a range of issues. We're across other issues as well, which are both interrelated and interdependent, such as we are advocating very strongly for legislation that will mandate the provision of motor vehicle service and repair information to independent, but also to dealers.
Yeah.
It's not clear that dealers necessarily get all of the information that's necessary for them to be able to provide the full suite of services from manufacturers as well. Recognising intellectual property, recognising capital investment, nonetheless, consumers must have the choice of being able to have their vehicles serviced at a place of their choosing, and it should not be restricted in doing so by having artificial restrictions placed on the information being provided to businesses to be able to perform that function. So
how might
there will
the
be some things
retail
that's a classic example of where we might have some differences of opinion.
And can I ask in that context, how might the retail models where such as direct selling or agency agreements flow down to affect training of apprentices, repair and service and repair?
Yet to be seen, and they are very important questions, Chair, because we're yet to actually understand what an agent model in new car retailing might mean for the future of apprenticeship training, the provision of those apprentices across not only a consolidating dealership base, who controls those. Our dealers are amongst one of the largest employers of apprentices in automotive professions around the country. We're yet to actually fully understand how, and this is not to be negative towards manufacturers. They have significant training programs. They invest in their product. They invest in the training of people to service their product, etc. But we're still unsure, because of the nature of these agent agreements, what implications there may be in terms of, if you take away dealerships and you take away or you allow further consolidation through this agent model, what implications downstream or upstream there are in terms of employment, in terms of apprentices, who controls the apprentices, who provides the employment to them, and I think the jury's still out on some of those critical issues.
And so what questions do we need to ask as a committee of, I guess, the likes of Deloitte and the Chamber of Automotive Industries to get answers to those questions?
Well, this is all about...
I'm assuming we need to get some advice about what is actually in these agent agreements that are currently confidential, for example, in the case of Honda.
That would be most helpful, because whilst we understand the commerciality of contractual arrangements between Party A and Party B, or manufacturer, distributor and dealer, there are some things which industry should be entitled to know, and that includes transparency on arrangements for, okay, we all understand that they may set the price for a vehicle and that it'll remove the intra-brand competition from dealers, etc. But what does it actually look like in terms of that particular business still being required to provide a service capability to Australian consumers? What does it look like in terms of parts supply? What does it look like in terms of other areas? Now, we noticed that some of them are saying it doesn't touch those particular parts of a dealer's business, but does it? I'm not
Indeed.
sure it's actually very clear or transparent to our satisfaction, at least at this stage. And then a natural flow on from that is, where does training take place? Who's responsible for training? What impacts does it have on our vocational education and training systems? And where does automotive fit into that?
And in your experience, things like training are generally part of the of the dealer agreements. I'll have a chance, I think, to ask them about this shortly. Or is it purely the service and repair standards, and then the dealerships will make their own arrangements around training in order to meet those standards?
It's more the latter, but that doesn't rule out that the requirements specified in a dealer agreement or the supplementary or additional operations manual or procedures manuals might go to some considerable extent about specifying what that level of training might be. Okay,
thank you. Over to Senator O'Neill or any of the other senators that would like the call.
Thank you. Thank you very much, Chair. Thank you, Mr Dudley. Thank you for your extensive submission. It's there have been a lot of high-quality submissions to this extended inquiry. I appreciate the work that goes into that. Just following up on the conversation or the questions that you've been responding to there with Senator Pratt, I note that Treasury is currently in the process of designing a mandatory scheme for access to motor vehicle service and repair information. I'm well aware of the issue, and you've indicated it's a point of contention between you and the AADA, who you are here supporting today, in their request for a mandatory set of principles.
Perhaps, Chair, if I can qualify, all of the associations are, I think, and I shouldn't speak on behalf of ADA, ADA has been supportive of the legislation.
Yep.
We probably have members who might rub heads because we don't know what the legislation looks like yet.
Yes.
We're not sure what the implications are. So that's what I meant.
And that's another process on another track. But I just want to draw your attention to the fact that is going to get mandatory status. Mm-hmm. And I want to go to your submission in some detail. I thank you for your opening statement, and I really would like a copy of that. I'm sure that you'll send something on to the Secretariat. And you indicated in your opening remarks that it become pretty transparent here today that there is a very big power imbalance in the motor vehicle industry, the automotive sales industry in Australia. So you've recommended, with regard to principles, that the government and industry agree to formalise principles that outline expected conduct and requirements between franchisors and franchisees, or between manufacturers and dealers. Can you please outline for the committee why you think the new agreed principles or specific industry franchise code should be mandatory?
Simply because our experience has been that without the ability to stop unilateral variations, which is at the heart of the move towards agent agreements, changes to dealer margins, changes to the broad superstructure, if you like, of agreements that are signed off, we're going to have ongoing problems. So unilateral variations must be stopped in the context of these agreements. And secondly, in terms of compensation and goodwill, what this morning did, because this committee is focusing on the relationship between manufacturers, distributors and dealers, is it has highlighted an argument that both ourselves and ADA have put forward for the last 20 years. In every inquiry into the franchising code, into the Australian consumer law, and indeed the ACCC's investigations into the new car retail market, we have consistently mentioned the power imbalance. We've consistently mentioned the attributes of that power imbalance. I think it was pretty stark this morning to see from two different perspectives how that translates. We believe that there has been some substantial change this year. For the first time in 20 years, we've seen more movement in this space, but it's still not enough. And so the mandation is necessary to do three things. It's to address the critical outstanding issues that have been mentioned in our submission and by others. It is to actually provide, if you like, clarity on the operating environment for the relationship going forward in this particular sector. And 3, there are required to be penalties and enforcement capability which acts as a deterrent to those who wish to continue to try and go down a different pathway. And as I think most witnesses today have indicated, and we join them, this is not indicative of every player in the market. There are players that are performing very well and the relationship is sound. But as we heard this morning, that can turn sour and southwards very, very quickly.
If I read your submission correctly, I think there's an indication in there that as a temporary measure, a set of principles could be voluntary, but with a government commitment and requirement for monitoring by regulators. Is that correct? Is that your position?
MTAA's position is that we have said that it cannot be voluntary, and our preference is for it to be mandated.
Okay.
But we have also heard that there may be constitutional or other problems in achieving that. We're not 100% sure of what those are.
Okay.
What we're saying is just simply having a voluntary set of principles isn't going to work. It's destined to failure. But if there's going to be somewhere in between, we'd be happy to take that to our members and get their view on what that looks like, whatever that might be.
But to be clear,
despite... to be clear, we want mandation.
Okay. And the sorts of problems that you're talking about in terms of power, I think are probably well demonstrated by one part of your submission. I just thought it would be worth reading this little bit into the record about the influence of a manufacturer requirements on a dealer in relation to warranty work. So that this articulates in your submission that a brand receives advice regarding changes to a warranty audit process, and the dealers get advised of the changes, the revised requirements, for the distributor to substitute a dealer claim for warranty work performed in future audit processes, and outlines the levels of chargeback and rights of appeal. Then included in the new policy is a directive that says that any warranty claim is going to be rejected if it fails to meet a new set of 12 mandatory steps, which were previously not the case. So it's just arbitrarily dropped down. We've changed our mind. Here you go, 12 mandatory steps you must comply. And then if one of those 12 arbitrarily determined steps weren't met, that would trigger a rejection of a claim with no right of appeal, which would leave the car owner who's got a car that's not working, a new car that they've purchased, would leave the dealer in the situation where they have to satisfy the consumer requirements by absorbing the costs themselves or not undertake the repair, exposing the consumer to lengthy delays and a resolution brought out because of the rules of the manufacturer. Is that a fair example of the way the current code allows power to operate? Is that a good example of how it looks when we get down and dirty there in the real world and people are dealing with this stuff? Is that what happens?
Senator, that's a very reasonable, which is why we included it in our submission, of a unilateral variation just thrown in without notice, without any regard for the dealer, and importantly, in this instance, in regard to warranty repairs, without due regard for the consumer. How is a consumer meant to know that there is this hidden agenda over here from the manufacturer or distributor of that particular brand that has a 12-step process that the dealer must satisfy before they can actually be adequately compensated for whatever the repair costs might be on that vehicle?
That's why I think this hearing is important, because it's not, while we are here looking after businesses, small and large, across the country, if those businesses fail, or if they continue to be subject to the kind of arbitrary unilateral change that we've just discussed there, the cost is going to be borne by ordinary Australians who expect us to be here doing the job for them of, making sure that they can go about life pretty safely and make sure that they're going to be able to afford goods in this country.
Senator, a unilateral variation like that, you could actually point to, in regard to this particular example, we know that this model of vehicle had problems. One could safely assume, because I don't have the commercial materials that underpin this, but based on the evidence and the materials provided to MTAA by certain dealers of this brand, it could be argued that the costs were mounting in terms of a particular problem with this model of vehicle.
So some bright spark comes up with an idea of, oh, I know, we'll change the rules.
We'll change the rules, make it harder to make a claim on it, and leave it into the dealer. When a relationship turns sour between a manufacturer and a dealer, these are the sorts of unilateral variations that can occur in a dealership arrangement, and it's left to the dealer to have to make some very hard decisions about they want to keep the consumer happy. And we have an Australian consumer law which is very, very protective of consumer rights, as it should be,
yes,
sitting over here, and dealers are acutely aware of what they're required to do under that ACL. But invariably, they are not given anywhere near the level of support that they should be by some manufacturers and distributors.
Yeah, and I do note that there's been much discussion about fixing that up, and as recently as the 6th of November, the Commonwealth and State and Territory Consumer Affairs Ministers agreed to strengthen existing unfair contract terms. I really look forward to that getting advanced as quickly as possible. But if I can go to probably my final question, given that we're going to close on 1 o'clock sharp. Noting that this inquiry came on the back of General Motors' decision to withdraw Holden brand from the Australian market, and we've since broadened the scope due to the evidence to this committee, are you able to detail for the committee the experience of your constituent members that may be similar to that of dealers affected by the behaviour of General Motors? And if you could give me a sense of, other foreign multinationals that look like they're going down the same path.
We stress again that not all manufacturers, distributors engage in exploitative conduct with their dealer network. However, when the relationship's ours, it can. And the protections are necessary to provide clarity to all parties in the market that they must abide by a set of rules, and that those set of rules are not to constrain a competitive market. They are the cost of doing business in this country to ensure that consumers are protected, that Australian businesses are protected, not from changes in the marketplace, but from behaviours and misconduct masquerading as unilateral variations to contracts, masquerading as 0.33% terminations, which doesn't include non-renewals, etc. And examples such as this. In the time since General Motors Holden and the compensation claims were finalised, if you can call it that, we've already seen 2 dealer agreements, draft dealer agreements, and this is straight out of these agreements, the dealer is not entitled to any compensation, payment, reimbursement or indemnity as a result of this agreement coming to an end by termination, expiry and the effluxion of time by any other means.
So all of that legal language often has ordinary Australians, glazing over. But basically it's, in real ordinary, good Aussie speak, as we'd find, was probably alive and well in a few pubs in New South Wales and Queensland last night. What does that effectively mean, Mr Donnelly? Put it in normal speech for us. So,
Senator, what it effectively means is what the Honda dealers provided as witness testimony this morning. That is, after 53 years, employing 100 people, a 30,000 strong customer database, the highest sales of any dealer in the land, it means nothing. That's what that clause means.
It means the contract that you have signed means nothing.
We'll take your goodwill and assign it to somebody else. It means that we'll take your customer database and we'll give it to somebody else, and we'll pay you what we think your business is worth, not based on all of the information that's available, but based on what we think is relevant.
That's like a bank just coming in and taking over somebody's house.
Essentially.
At a point of, at some point, and just saying, well, I'll tell you what it's worth. And if you complain to anybody, this contract will have confidentiality clauses in it. No Australian would put up with that kind of power, and no government should allow that to be the reality of Australians, to be intimidated in that way. No matter how big a business you are, governments are in the job of making sure that businesses are safe and that jobs are kept safe and that Australian consumers can safely go about buying a good car at a good price. And sometimes that
Thank
means
you,
the government needs to
Senator.
get in. Thank you,
Thank you, Senator
Chair.
Onion. I'm sure there are appropriate closing remarks for our hearing today. I'd like to thank all of our witnesses, and I note that Hansard will be in touch with you all, and any questions on notice to be returned to the Secretariat. Once I've got the all clear that we're no longer broadcasting, we will have a short private meeting.
Yeah, so can we just ask, off the record, broadcast, have you finished?